Good morning, everybody. Welcome to today's webinar, where our guest speaker will be Andrew Hinkes. Drew is a practicing attorney. He's a partner at K&L Gates, based out of Miami, one of the leading experts in crypto litigation. And he also is the co-instructor with me of the MBA JD blockchain course that we've had at NYU in different iterations since 2014. The first time I met Drew, he was giving a talk. We invited him when we were just starting to teach and research in the fintech area in the early days of Ethereum. And this was when the DAO, the very first famous the DAO, was launched on Ethereum. And he gave a presentation about what if this thing were ever hacked? Who could you go after and sue and hold liable for this? And not even a week later, exactly what the seminar was about actually happened in the real world. And I think it's led indirectly, or maybe even very directly, to the paper he's going to be discussing today. So without taking up any more time, Drew, welcome. We will go until 12:15, but we'll be happy to take questions in the Q&A box as we proceed.
Great. Thanks so much, David. Thanks, Fahad. Thanks for everybody with CBR for having me. And thanks for the wonderful introduction. I'm going to go ahead and share my screen so that everyone can see the slides here. David, can you confirm the slides are visible?
Looks good, yes.
Okay, wonderful. So I was invited today to talk about a paper I published called The Limits of Code Deference. And if you've ever seen my presentations, you'll know that my slides are deadly dull and plain with the occasional picture peppered in. And so my apologies in advance for a perhaps less than dazzling presentation, but hopefully the content makes up for it. Code deference is an issue which is of importance for folks who want to try to organize persons around smart contract tools, blockchains, and digital assets in order to engage in collective action. The concept of code deference seeks to answer the fundamental question of, can we actually use the code to do things? Or will the legal system ultimately intrude and impinge upon our ability to organize ourselves around technology tools because people are still involved? And this becomes important when we start to use things like DAOs in order to conduct affairs, which generally would be conducted either by legal individuals or through individuals acting together through legal entities pursuant to more conventional types of tools. And so the big questions that are considered here is, if we have a bunch of people that are using technology tools together in a DAO, can those people, those humans, those legally addressable people, bind themselves to whatever the smart contracts do, no matter what? Because they're people, they need to agree, and generally speaking, they're going to need to agree in a legal way. And so the next question is, are agreements for those people to defer to the smart contracts and their execution binding or not? And the third question is, if everybody decided that they wanted to opt out of the law in creating an entity and operating an entity together, could an organization compel its human participants to always accept the outcome of code no matter what? And if this doesn't work, why are we wasting time creating DAOs, putting people into these organizations of various types and flavors that we'll talk about? And is there any reason to do this at all? If you've been paying attention to the crypto world, you'll understand that smart contracts have become a foundational primitive for the creation of increasingly complex systems. We could start in 2008 with Bitcoin, which created a decentralized peer-to-peer online mediated value transfer system. Adding to the sort of base layer of Bitcoin is the idea of smart contracts. There is no canon definition of a smart contract. Nick Szabo conceptualized them as the ability to use hardware and software in order to organize contractual relations so that breach could be made more difficult or more easy depending on the designer of the system's desires or perspective. But there really isn't a canonical definition for what is a smart contract. Smart contracts at various times have been marketed as replacements for legal agreements. We'll talk very briefly about why that's complete nonsense. But the key thing to remember about smart contracts is that they operate deterministically. There's a piece of code that can take system control of a digital asset. And if that piece of code receives the appropriate data, it will execute in accordance with what the code allows. And so from my perspective and the perspective of other scholars, the emerging best practice as far as how to think about smart contracts is that they are instructions to computers. They can be part of contracts, they can be used to perform certain obligations under contracts, but they should not be thought of as independent freestanding legal obligations or even a memorialization of a legal agreement. We'll talk a little bit more about that in coming slides. When we think about the types of ventures that we want to talk about, the key thing to think about here is that smart contracts in a technology vacuum aren't terribly interesting. They harken back to early ideas like vending machines and other essentially automated agencies of legal actors that can act on their behalf, and that as they became increasingly complex, can use their software and hardware to moderate the way that parties interact. When smart contracts were deployed on top of blockchain systems, they became much more interesting because they allow parties to automate transactions of value on the native layer because they're natively digital. We think about this as facilitating financial transactions because most people think about crypto assets as being some increment of value. But these systems and this technology can work for any kind of digital asset, which might include storage space, information, and so forth. So we should think about this more broadly for non-financial applications, even though for the moment, most of these applications seem to be of a financial benefit. This is sort of the perfunctory, is this a legal agreement or not slide. I think at this point, most people understand that code residing at a smart contract address does not generally create a contract. A legal contract, at least under US law, generally requires offer, acceptance, consideration, and a meeting of the minds or a parallel understanding of the endeavor to be interacted with or to be engaged in by the parties. Code sitting at a smart contract address under certain circumstances could be part of an offer. Transacting an asset to a smart contract address where there's a code, where there's code waiting for the asset, under some circumstances could be viewed as acceptance, and receiving the value through the smart contract and smart contract executing under certain circumstances could be viewed as consideration. But the big picture here is that nobody, at least to my knowledge, sees a smart contract on a blockchain address and sends value to it without any context. Most users who decide to interact with smart contracts will have some kind of information about the smart contract. There will be some party that's making a representation about what the code is, what it's intending to do, what will happen if a party transacts value to it. Very few users of these systems are technology native enough to review the smart contract code and understand what it means. Most users of smart contracts are not using one isolated smart contract. They're generally engaging with ventures that are crafted from webs of smart contracts that are designed to recreate financial software. And so the result is that smart contracts are not usually going to be something that a party uses to make an offer and through which engagement will be viewed as acceptance. They generally are going to be used as parts of larger agreements. So like I said before, the zero information smart contract use probably doesn't exist. There might be a small fraction of those who actually use crypto that can actually read code and understand what it means, and then based on that understanding, decide whether to use it. There have been certain instances that have come dangerously close to this sort of code-only decision-making. A very well-regarded smart contract developer named, and I'm sure I'm gonna get his last name pronunciation wrong, Andre Cronje, who is behind the Yearn Finance protocol, very famously used to talk about how he tests in prod, meaning if he has code that he's working on, it's production ready, anybody can use it. And because early entrants into DeFi protocols at various times have been resulted in those early entrants making a ton of money, folks at one instance sent a whole bunch of value into code that he had posted on his own GitHub repo without really any context as to what the code was going to be. There were some representations that it might be a new platform that he was going to create that was called Eminence. But the folks that sent their value to the smart contract wound up having that smart contract exploited by another party that found a problem with the code. And the entire experience kind of sent Mr. Cronje out of the DeFi protocol developing world because he ran into some of the problems that we're going to talk about in this presentation. So the best way to think about smart contracts from a legal perspective is that they are part of a greater context. They're either part of a bigger venture for which there are human language representations, or they are going to be part of a transaction where someone is asking another person to transact. And so Professors Coney and Hoffman in their paper talked about smart contracts as being transactional scripts that emerge as part of a contract stack. And I like this interpretation because it sort of plants smart contracts into a easier to understand body of law. We have humans making representations and promises to each other, and we're simply using technology tools in order to act out some of those promises. If we didn't think about it this way, we would run into some really strange interpretation issues. Who in a litigated matter should be the one deciding what a ordinary reasonable person encountering a smart contract would think? Is it reasonable to think that an ordinary person would not review code? Should we think that ordinary people that are using smart contracts should be able to read code? These are really important and interesting issues. They'll be determined by courts over time as these issues are litigated. But for those that are seeking to create systems and want to embed certainty, they create a lot of ambiguity, which is the opposite of what you're going for. And so you have to think about what would a reasonable person do and what representations would be relied upon. We'll touch on that a little bit further as well. We also have to deal with the code is law meme, which floats around in crypto social media and among some of the less educated or less acquainted with legal regulation parts of the industry. And this is sort of a bastardization of Professor Lessig's observations about the internet. What Professor Lessig said was that there are structural differences about the internet that may require the law to adapt around it. Classic example is people can basically tell in the real world whether they're being followed. On the internet, it's very difficult to tell whether there is someone who is surveilling your movements, because the structure of the internet generally does not allow a user who's using a web browser to understand whether someone is tracking them. We obviously have created laws that allow for people to understand whether they're being tracked, that indeed require people to disclose if they're tracking them. That's what all these policies that talk about cookies and all the rest are about. And so folks in the crypto industry have taken this code is law idea and kind of twisted it around to take the position that people can create systems that limit the powers of their participants. And that because the system limits the power of those participants, whatever the system allows is all the participants can do. But this is a kind of misunderstanding of the way that these systems work, for the simple reason that all of these systems include people. And people are still legally cognizable, and people are still subject to laws. In fact, so are computers. So are people who host computers, people who operate computers, and people who provide services in order to support these blockchain networks. So although the idea of code is law is interesting, and it may be something that we would want to strive towards, the current state of affairs does not necessarily support code is law for reasons that we get into in this presentation. If a party decides that they're going to use a system that restrains their powers on the system, we get to the philosophical question of whether we should want parties to ask courts to reverse things that happen on those systems. Perfect example is a Bitcoin user who fails to properly protect their private key. In this particular instance, let's say that David has a Bitcoin private key that controls the Yermak family fortune. Somebody shoulder surfs David, sees his key, takes it down, and divests the family fortune of their holdings. To Bitcoin, there is nothing wrong with the transaction that occurred. All Bitcoin cares about is, was a properly formed message causing a transaction of value submitted to the network? And was it confirmed? In the hypothetical I just addressed, the Bitcoin system doesn't really care who's using that key or why. David, understandably, would be a little bit unhappy about this because no one wants to lose the Yermak family fortune. And he would likely attempt to figure out who shoulder surfed him and took away his assets. And so there would likely be a claim for conversion or a criminal case brought for theft under those circumstances. But the key distinction here is the system didn't care why. The law that governs the people cares why. And so I think that most people who are advocating for code as law may actually find that they don't want what they're asking for. Or it could be that we actually do want systems that are created using these webs of smart contracts to be immune from law altogether. There are good reasons why you may want this. We'll talk about that a little bit later as well. So I keep talking about these systems that are made out of smart contracts. What I'm really talking about here is a continuum of different sorts of structures that can be built using blockchains, digital assets, and smart contracts. I'm going to roughly key this on the nomenclature created by Vitalik Buterin in his 2016 writing about decentralized entities. I don't have the name of the article on top of mind, but it's cited in the paper, and it's a easily found piece of work. And he calls, among the different types of entities that he discusses, he talks about DAs, which most people now call dApps, DAOs, which aren't really talked about very much, and DAOs, which are probably more like DAOs than DAOs. So let's do a quick walk through the taxonomy here. dApps, or what Buterin called DAs, are essentially smart contracts that are publicly available, that can be used by any number of persons, that operate on top of a blockchain, that can take control over digital assets. And in his formulation, it allows an unbounded number of people to operate on both sides of the dApp. And so that brings to mind a dApp where there might be a party engaging in one side of a transaction and another party engaging on another side of the transaction. That is, two parties might use this application in order to engage in a transaction with each other. To be clear, not all smart contracts, dApps or DAOs, are necessarily multiplayer games, so to speak. There are applications out there, MakerDAO is one, we'll talk about it very briefly, that can be argued are single user applications, meaning a person or another piece of code can use that DA or that DAO in order to obtain a service or a product. And in so doing, it's arguable that they're not actually engaging with another legally addressable entity. It could be that under Buterin's formulation, it doesn't matter whether the person that's using the decentralized technology is a human person or a robot or a piece of code. But it seems as though most of the current applications that are being offered as dApps don't necessarily require two different sides of a market to be engaged in. The application or the dApp is generally designed to take control of a digital asset and to either alter it or transact it to another wallet address based upon a piece of information that it receives. And so the key thing here is, although the word is a legal word, I'll use it anyway for a system function, smart contracts are custodial. And what that means is it's not clear who controls the asset once it has been negotiated to the control of the code. We have these legal questions of who owns and has rights to a piece of property, piece of digital asset that's controlled by a smart contract at a given time. And that's one of those sort of lingering questions out there that will hopefully be determined in the future, likely to show up in the bankruptcy context, but it's sort of a question that we haven't really seen yet addressed. So the big picture is dApps are used by an unbounded number of persons in order to obtain some sort of transaction that either modifies or transacts the digital asset to another place or person. David, I see that there's a few chats and a few questions. Is there anything that we should cover right now?
Yes, Kathleen DeRose has a question. Kathleen, I've unmuted you if you'd like to ask the question live.
Oh, sure, thanks. So some of these transactions on exchanges like Uniswap and Aave, specifically flash loans, I'm wondering how you think about words like binding or executed or enforceable for flash loans that simultaneously exist in a executed and unexecuted state, kind of like as if they were both gas and liquid at the same time. How to get your head around that?
Yeah, so it's the uncertainty principle of flash loans. For those who are not deep in the weeds, flash loans are a new DeFi-driven primitive that allow parties to, at a very low cost, essentially borrow an extremely large amount of a digital asset, provided that the user of those loaned assets creates a transaction where those assets are used and returned in the same transaction, including the payment of a fee. These flash loans are used generally for two reasons. One is to exploit market arbitrages. generally by manipulating a oracle that's used as a pricing mechanism for a venture that allows for transactions, so that a market finds itself out of alignment with other markets, and the party using the flash loan can exploit that for profit. That's the sensationalistic use that we see documented all the time. The other use of flash loans is to do things like close out leveraged positions where there's times of high volatility. Say that you have a collateralized transaction on MakerDAO, and you are concerned that the value of your collateral is about to fluctuate or is fluctuating, and you want to figure out a way to just close out your position very quickly before you start to take on any liabilities or worry about losing your collateral altogether. Flash loans can be used as a fast and relatively inexpensive way to close out a collateralized position. I think your question was, how does the law think about a flash loan where it only exists when it comes to exist, and it basically only, the transaction only exists for 14 seconds? Is that what you're asking, Professor?
Yes, thank you.
Okay, so my sense is that you would look at that, the simplistic way to look at it is that this is a loan. There is a binding promise to repay that is actually enforced through code, which is kind of interesting. And it, obviously, you're not taking out and executing loan documents as you would in a conventional loan. I don't think that the SEC would look at these as demand notes. They are self-enforcing based on their technical attributes, which I think is fascinating and a really novel development within this industry. Are there any other questions, David, or should I hop back to the slides here?
Let's carry on, and if there's more, I will let you know.
Great. So we covered dApps. Decentralized organizations are taking dApps to another level, essentially. They take dApps and they organize them into systems that are intended to act on behalf of human participants who delegate certain things that they would normally do themselves to code. And so this is smart contracts on blockchains, controlling tokens of value, allowing humans to act collectively. And these are, I would argue that many DAOs that we see now and that people talk about now are actually more like DAOs because they lack the autonomous factor. But these are people that are using code to act together to affect digital assets of value. And this is mostly what this paper talks about. To give you an example of what I mean by a web of smart contracts, I give you a simplified diagram of the Maker protocol, which enables MakerDAO vaults. Each of the boxes and circles are a unit. Well, the circles are users. The boxes are units or logical groupings or modules of smart contracts that act together in order to do a thing. For those who are not familiar with MakerDAO, it is a system that allows you to send collateral in the form of Ethereum to a smart contract address. And in exchange for providing that collateral, a user receives the ability to draw down an amount of a new asset called DAI, which is generated by the system and which purports to be a stablecoin. The system works like a lot of margin contracts. If the value of your collateral drops below a certain ratio, you either have to replenish the DAI, add collateral, or your collateral is at risk of being liquidated. And so when we're talking about flash loans, we're thinking about their use as a way of quickly replenishing collateral in order to pull collateral out so that you don't get liquidated, or of replenishing DAI so that you can pull the collateral out. You can basically top up your collateral so you don't get liquidated, or you can replenish the DAI so you can pull the collateral out. And so when we think about webs and smart contracts, we should stop thinking about analyzing smart contracts atomically. We shouldn't think about one string of code on one address that is doing one thing. We need to think about these as complex software systems. And if you're thinking forward to the way that a user interprets the interaction, most of this, if not all of this, is generally obscured. A user is, under most circumstances, not going to be drafting command line like directions to a specific smart contract address in one of these modules that you see represented by these squares and rectangles. They're going to use an interface. The interface is going to reduce those communications to mouse clicks and to typing, things that are a lot more human friendly. And so when we start to think about what a typical user of MakerDAO, for instance, thinks about when they're using it and what representations they are understanding, we have to really back away from the idea that anybody is operating based on what the code says. Because I'm making this up, the vast majority of MakerDAO users probably are not scrutinizing the code in all of these modules in order to understand what they're doing and then interacting with them via command line. They're using tools that simplify the process. And so instead of thinking about the code, we should be thinking about the representations that are being made about what the code will do, as understanding where users get their expectations. Zooming out to DAOs. DAOs, as conceived by Buterin, are things that probably don't exist right now. They're basically online sentient robots that hire humans to do things that code can't do. I would argue that the closest system we have to this is Bitcoin, and that there are some real issues in that assumption. Right now, we just simply don't have living things on the internet that require people to do things that only people can do. And so really what we're looking at here are massive organizations of people that are using tools in order to manage powers over digital assets. The whole thought process behind a DAO is that we could get rid of the foibles of human nature and we could code in using logic what a group is going to do. It's intended to be transparent because all this code lives on blockchains, and with blockchain explorers, you can see it all. And it's intended to be predictable because the code is going to do what it's going to do. If you can see what the code is, if you can read it, you'll understand what will happen when it executes. And the ultimate goal here was to eliminate this ultra vires problem and have the organization run in a predictable way. What we have seen is that people have built systems that are probably closer to DAOs than DAOs. And they're calling them DAOs anyway because it's interesting. But they exist to service the humans, not for the humans to service the venture. The ventures that are being created are kind of falling under two flavors. You've got incorporated entities where participants in those entities are using blockchain tools like smart contracts, wallets, and tokens in order to govern the entity and to execute their will over certain digital assets. And then you have the illegal DAOs, which are entities that are not incorporated under the law of any jurisdiction, where you have people that are using those tools to control assets. In a incorporated DAO, what you really have under the hood is not that different from any other incorporated entity. You're simply using different tools and often different governance in order to operate that entity. We have at least 3 jurisdictions in the United States that have laws that were probably encouraging DAOs to be created. Vermont was the first. Wyoming probably got the most attention. And Kentucky recently also passed a law facilitating DAOs. These laws essentially create bespoke types of LLCs that require certain disclosures as to governance and that otherwise require the LLC to do the same things that other LLCs need to do. Disclose management, operate pursuant to the same formalities, pay their taxes, and do all the rest. The illegal DAOs, on the other hand, are doing similar sorts of collective control of digital assets without the legal compliance. And they've been able to do this partially by ignoring law in some instances, and in other instances by attempting to characterize their activities as those that would not subject them to regulation the same way that they would be regulated if they were legal entities. So big picture, the DAO is intended to be something that humans use. A DAO is intended to be a thing that employs humans, and we probably are not at a Buterin DAO yet. And between the two, we have the legal entities, which are basically using bespoke tools to operate the entity, versus the illegal entities, which are an undefined mass of people using technology tools to manage digital assets. So when we think about decentralized ventures, for these purposes, we're really going to think about both, because there are novel questions for each one. If we think about the incorporated entities, we have the ability to use contract law as a way of trying to control the expectations and conduct of our participants. If we don't use the legal entities, we either take the position that we are not using legal relationships, or we take the position that the law will imply legal relationships, which can have sometimes better and sometimes worse results. But this slide is intended to sort of frame out what we are thinking when we think about decentralized ventures. They are massive, scalable, and they are generally obfuscated so that we're not thinking about a single given piece of code. And for the illegal DAOs, it's hard to infer expectations of participants. This is a slide created by somebody online called Koopa Troopa, which if you are not deep in the crypto weeds, you may not have seen something this hard to look at and busy. If you are deep in the crypto weeds, you've seen 20 different slides like this at given times. And this is intended to show some of the more prominent ventures calling themselves DAOs. The protocol DAOs on the upper right are DAOs that purportedly manage and operate appliances that are available online to be used in order to engage in financial transactions. There are variants of this like service DAOs that are intended to perform services for participants as opposed to being kind of an open application. And then you have social DAOs, which take the position that they're not necessarily there for financial purposes, but they're for other social purposes, many of which are just cloaked as actual financial purposes, wearing a different hat. There are some interesting media DAOs where participants vote on what is going to be covered, which is kind of a novel and interesting mechanism for DAOs. You've got on the upper left-hand corner what they call DAO operating systems, and these are actually the code that can be used to implement a DAO that effectuates the ability for parties to vote with tokens and control assets and wallets and so forth. The investment DAOs you see include Cartel and the LAO, and these are two systems that were analyzed in the paper to look at their approach to attempting to bind their participants to the outcomes of code. And because these are investment DAOs, they are necessarily legal DAOs. The 40 Act, among other laws, require groups of people who come together for investment purposes under most circumstances to engage in certain compliance, which necessarily carries over to these DAOs as well. It's not to say that there aren't other DAOs out there that are doing regulated things without regulatory compliance. I'm sure that list far outnumbers the list of folks that are in this little circle here for investment DAOs. And DAOs, because of the modularity of the code and the ease of spinning up these systems, there are probably orders of magnitude higher numbers of DAOs than those that are displayed here, but these are some of the more significant DAOs. So why are we talking about all this? Now that I've framed out what DAOs are, how we should think about smart contracts, what's the problem that we want to think about here? The problem is that this technology doesn't necessarily always do what its proponents say that it's going to do. Smart contracts don't always dispassionately logically execute and provide end states that are expected. There can be code defects that are not observed. There can be code defects that only come to light when various code segments interact together. There can be attacks, hacks, or exploits that cause certain code segments to behave in ways that aren't expected. Oracles, which are technology service providers that feed the triggering conditions to smart contract code, can have their own flaws. They can be interested parties who have a reason to manipulate the data that's provided. They can be manipulated. This goes back to Professor DeRosa's comment earlier. The flash loan attack is all about changing a piece of information by manipulating a thin market where the market price for an asset is used to price another asset on another market and then exploiting that market as well. So Oracle flaws and vulnerabilities are a major problem. We've also seen oracles work just fine, but underlying level 1 systems not work well. MakerDAO notably suffered an $8 million loss in its overall venture capitalization when excessive Ethereum system traffic resulted in oracles that were supposed to provide pricing to its liquidation mechanism not being able to get the pricing information through. It was giving the right information, but Ethereum was so clogged that it couldn't get the information through. The result was people were able to purchase liquidated collateral for zero. Some people got a windfall and the system collectively took a loss. Finally, smart contracts are not written from scratch every time. Like many other software development communities, code reuse, software library reuse is common, if not endemic. And so if your contract inherits flawed code from other contracts, the same defect or flaw in those contracts will be inherited into your contract as well. Another concern for illegal DAOs, that is those that are not based on incorporated entities, is governance. Governance is hard. Making up new governance is really hard. We have governance in established business entity types that have been developed over centuries. And there are still those who call for traditional governance on well-established legal entities to be revised or amended, because there's always ways to improve it. In these entities, there are typically radically different, or not typically, there has been radically different governance attempted, and system governance may vary widely. There are instances in which large holders of governance tokens, which are digital assets that may be used to interact with governance modules in order to make decisions about the use of resources of a DAO, or in some cases, changing the code of the DAO. The governance may fall into traps where there might be cartels, or there may be large holders that, based on the governance, are able to basically push through whatever they want. The governance may call for a certain number of voters to participate, and it may never reach quorum. That was one of the issues that doomed the DAO. And you might have a bunch of actors who decide that it's a lot easier to bribe others than it is to actually get a legitimate control. And depending on what the code allows and the representations made in illegal DAOs, all these things could be totally okay, or all of these things could simply be unaddressed. A user who finds themselves aggrieved or perceives themselves to be aggrieved by cartel action, or by folks who might be taking active steps to try to suppress participation so that quorums can't be reached, or people who are outright buying votes by bribing people, may decide that they've been harmed. And so then we get back to the question of, where does a user come up with their expectations about what is to occur when using one of these systems? Also, in these systems, users may attack the system or attack others in the system, harming them directly. And so there's lots of uncertainty, and there's lots of opportunities for harm to be visited upon a participant. The question becomes, what happens when someone goes to court? When someone goes to court, they can wreak havoc in a DAO. And there's a bunch of reasons why, starting with the idea that they're not designed around the law. DAOs that are legally enforceable entities are designed around the law. Illegal DAOs are not designed around the law. First of all, code resists certain expressions of court power. If you have a DAO that is truly operating as a robot, meaning there is no ability to update the code, it is being operated by nodes that are supporting the L1 network as a piece of code that sits on the blockchain ledger. It could be that there is no legal party that can be forced to comply with a litigation hold or a court-entered injunction. If there is a party that could comply, it may require that somebody actually go in and rewrite code, or that somebody go in and stop code. It might require that those node operators or miners or validators have to actually stop what they're doing and change their code for a code modification to become effective. And I don't think there's a system out there, with the exception of private systems, that can actually track down all of their nodes and validators and get them to comply with a court order. It may, if dev keys are burned, and if you can't find your validators and node operators, it may be technically impossible to comply with a court order. We also might see that these sorts of structures and entities are resistant to equitable remedies. A court order that requires a certain smart contract to stop operating would obviously affect other users of the code. You might have, in a MakerDAO example, a bunch of people who are trying to liquidate other people's positions. The court enters an order, the code has to stop. They're not able to liquidate out positions. There may be people who are harmed because of this. A lot of these systems create new digital assets as an incident of their operation. As was alluded to in Professor DeRosa's comments, these systems are interconnected. DeFi specifically, which builds on top of DAOs and dApps, introduces this concept of compositionality, which is an asset created in one system can be used in another system for another transaction. And so if there's a system that relies on, if system A relies on system B to provide the pricing for an asset or to create a steady stream of another asset for system A to function, if system B is shut down, it may harm system A and it may harm users of system A. And finally, all of the folks who are holding on to the assets created by the operating system may find that they are harmed because their assets may not be negotiable anymore. Practically, the result here is that remedies that seek to interfere with the operation of smart contracts are probably not tenable. They probably just don't work. And so practically, we're probably limited to ex post remedies. Finally, we get to the questions that David alluded to at the introduction, which is, who do you sue, where, and for what? Most of the illegal DAOs do not have an AML KYC requirement. Many DAO operators operate under pseudonyms, and to interact with a DAO generally only requires you to have technically compatible hardware and software and control of the right digital asset. These digital assets are generally traded liquidly 24 hours a day around the world in borderless exchanges. So you may not know who you can sue, and the list of people who you can sue may change over time. Forum and venue, where you're suing, you got to figure out where your people are first. Who are the humans or the actors that you think the court can summon power over, and where are they? We don't necessarily, to my knowledge, with the exception of China, we don't necessarily have internet courts. It may be that in order to appropriately handle lawsuits over these sorts of issues, you might need a court that can assert jurisdiction over the internet. I'm not sure exactly how that would work, but it might be something to think about. What kind of claim do you bring? Do you want to take the position that there are implied contracts due to everyone's conduct? Do you want to claim that you were just stolen from if somebody takes an action which results in you suffering an individual loss? Do you have standing to represent the entire DAO just because you hold some tokens? And finally, who represents the DAO itself? If it's not a legally incorporated entity, odds are a judge will look at it and say, looks like a joint venture to me, or it looks like a general partnership for me. Some DAOs have sought to create leadership councils or groups of folks that are designated as agents. And if you start to put together people in an illegal entity that are acting on their behalf, it really seems like you're kind of rebuilding the idea of managing members or a board. But most DAOs of the type that we're talking about, the illegal DAOs, try to avoid any appearance of centralization. And so this creates problems for these DAOs when they try to interact with the real world. So the concept of how to deal with these issues is code deference. And code deference is, once again, can you require your users to be bound to the output of the code no matter what? And it's not clear that you can. But if you wanted to try to build this, you need to, at minimum, have some form of human agreement. Because ultimately, these systems still exist to serve the people. Again, we don't have robots that live on the internet hiring people quite yet. Because we need humans to opt in, we essentially need binding agreements. And so the first question to think about is, do we actually have the ability to create binding agreements for somebody to not sue? The paper analyzes 3 different approaches to code deference. We start with the DAO, which was the famous DAO that epically creating all sorts of really interesting legal issues and brought the SEC into the world of crypto. We have the Cartel Ventures DAO, and we have the LAO. The DAO was an illegal DAO. It did not incorporate anywhere. The Cartel Ventures DAO and the LAO are both investment DAOs. They exist as legally incorporated entities. They're both bespoke Delaware LLCs, and they both take slightly different approaches to attempting to create code deference by their users. Brief recap on the DAO. This was the attempt to create a investment fund using code. For 28 days, people could invest. Reports vary as to the amount of value that went in there, but let's call it $150 million, or about 13% of all of the ETH that existed at the time. There were 4 main groups of people involved. You have the folks called Slockit that wrote the code, which incidentally was initially created to create blockchain-enabled bike locks so that you could buy access to a bike over a blockchain. They decided to use their code for something a little bit different. You have investors who are people who paid ETH to get tokens called DAO tokens that would be used to participate in the DAO. You have contractors who were a subclass of investors that had contributed a certain amount of value and that were able to propose projects. And projects were uses of the aggregated capital that were intended to benefit all of the investors. And finally, you had creators who were limited role gatekeepers. Their job was to whitelist projects to make sure that that the code that went along with a English language description of a proposal or project matched. The code didn't do something that the human language said it wouldn't do. And they had certain discretion to modify the governance in certain instances. As mentioned, the DAO tokens were how you interacted with the venture. They were almost immediately listed on exchanges, and so initial investors had immediate liquidity for their tokens. This complicates the understanding of who is actually a participant in the DAO because participation interests could change at any time. You had a 20% quorum requirement. You needed 20% of people who hold tokens to participate and a majority to vote. And if you decided that you wanted to take your toys and go home, you wanted to pull your assets out of the DAO, you had to do something called split, which took about 2 weeks. And as we learned, created some technical issues. No contracts were signed, no AML KYC was engaged in. The best you saw were a bunch of conflicting disclaimers on a bunch of websites, at Ethereum code addresses, at GitHub repos, which said a bunch of different things, including this isn't a security, this might be a security, this isn't a contract, this might be a contract. Really nothing concrete enough to wrap one's arms around. The theory behind all of this is that you would have people who would want to act together, and that the lack of any regulatory impediment to participation would create the ability for people who otherwise don't have access to venture capital to pile in, and that they could use these technology tools without legal compliance in order to create new opportunities for investment. We had terrible game theoretical issues with respect to governance, and we have moral hazard issues which are still being played out in DAOs now. How does an illegal entity sign contracts? How does an illegal entity determine that people who it might ask to act as its agents actually do what they're told? How does a DAO punish someone who does not act in a way that is expected? And in my law practice right now, we are working with clients to address these issues. Harkening back to some early research by one of our colleagues, Carlo Reyes, recently some decentralized protocols and DAOs have been creating trusts that work at the behest and under the direction of DAOs through their governance structures, so that there is a legal entity that can control assets, including control non-digital assets, and that can go and do things like get bank accounts, and that also can sign contracts. We recently, for a client, created a trust and used that trust to allow an illegal DAO to sign a $40 million sponsorship agreement with a major North American sports team. We got the entire arrangement, including all the disclosure about the DAO and the trust that was created, approved by 2 multi-billion-dollar companies, and we were pretty proud of that. But it does not solve every question, because it still creates issues of enforceability. In the trust that we created, one of the really interesting questions was, how do you punish a bad trustee? And we ended up going with a structure that relies on one trustee acting as an enforcer against other trustees. It's not perfect because you're still relying on 3 people to do what a whole bunch of other people who don't have a legal identity have instructed them to do. And so with a structure like this, we run into the problem of, do we care about the code, or should we just be looking at consumer expectations born of communications about what the project would do and what the web of smart contracts is expected to do when it executes? Do we have a contract here at all? What are we looking to when we want to imply a contract? I think the beat in the drum that the code is not where you look you look at marketing, you look at communications. But the really interesting question is, how do you come up with what an objective person would have expected when using a platform that disclaims relationships, where there are multiple sources of information about what the platform will or won't do, none of which come from the creators or deployers of the code? It creates an interesting interpretive problem for courts when trying to figure out what a reasonable person or how a reasonable person would have viewed the opportunity. It makes sense that the court would use the reasonable person as its inquiry. It's basically how courts look at offerings of securities, notwithstanding whatever wiggle words would be in the offering of security. The court's going to say, how does a reasonable person look at this? So I would expect the same standard would apply. As everybody knows, the DAO was attacked. Somebody, or David, did you want to hop into the question?
Yeah, Drew, before we leave it too far behind, I wanted to go back to your sports example from one slide ago. Why would a DAO want to sponsor a sports team? And if it did want to have these kinds of organization or interactions, why would it organize itself as a DAO in the first place?
So the DAO at issue is the DAO for a blockchain called Terra. And Terra is a blockchain that creates a stablecoin called Luna, or I'm sorry, called UST. They are a DAO of holders of an instrument called Luna. They exist in order to do things to encourage adoption of the UST instrument and the Luna instrument. And so, like a bunch of commercial actors who are seeking to bring users to their platform, if you watch the Super Bowl, you saw like 9 different crypto commercials for various intermediaries that make friction on people's trades. Protocols have their own sets of cheerleaders. DAOs often exist in order to encourage adoption or use of their technology. And so a DAO may want to sponsor something in order to attract attention to the DAO and to the product over which it governs. In this particular case, it was for Terra, and it was to encourage people to become aware of Terra blockchain, the Luna instrument, and the UST stablecoin. But I agree with you, David. You do have the question of what are DAOs really for? And I don't substitute my own judgment for the incredible creativity of the people who are working out in this industry. But my sense is that simply giving away money in order to promote an entity perhaps isn't the best use. I know that we've had Uniswap, which, for instance, created at the behest of some Uniswap participants out of Harvard, created the DeFi Education Fund, which exists to promote information about DeFi technology and interact with government and what have you. So it's essentially, how do we promote the technology that we're governing? Seems to be the use case. I saw that one of the participants was raising his hand a few times. I don't know if we want to.
Yeah, that's Suman Banerjee. I unmuted you, so please go ahead.
Suman, are you able to unmute yourself?
Yes, now I can speak.
Hi.
So the basic idea in India also, the cryptos are spending a lot of money in sports, because see, the large part of the profitability depends on how uninformed and noise traders get into the system. And these are times when a lot of uninformed noise traders kind of follow these sports, and they are attracted by these very sophisticated advertisements that we are seeing. So sports type advertisements are popular for getting this noise base, creating this noise base, in my opinion.
Right. So sports are a luxury good engaged in by those who have the means and resources in order to engage in luxury. So it's a logical place to advertise for a financial product. I think there's a reason why Rolex sponsors Wimbledon, and there's a reason why if you go to an F1 event, you'll see major banks sponsoring events. So crypto, I don't think, is unique in that respect. I think what might be unique is the novelty and relative experimental quality of some of these ventures, weighing in and putting themselves on parallel footing with perhaps more established types of brands and companies. That I think is novel and interesting. As to whether anyone is misleading anybody about anything, I think that's a different issue. Anything else, David, that you want to touch on before we proceed?
No, let's return to the presentation.
Thank you. So as everyone probably knows, and as David alluded to in the introductory remarks, David was nice enough to invite me to NYU when I was but a mere practicing lawyer and talk about a paper analyzing the legal structures of the DAO and all the governance issues and all of the securities law problems. But the big picture was that there were a bunch of flaws that people were aware of, but the governance system that was in place required quorum in order to do anything, including quorum to repair the code. Someone, no one's really quite sure who, did their research, saw that there were a number of issues with the code and used a known vulnerability to exploit the code and remove a large amount of value, far beyond the value of the tokens that the person had, which leads to the inference that they took value that they shouldn't have, and a layperson would say that they stole from the collective. There were a lot of questions and discussions about who is obligated to fix it and if it could be fixed at all. And the result was that after a lot of panic, Ethereum, the layer 1 that hosted the DAO code, decided to fork the layer 1 blockchain in order to essentially eviscerate the DAO's code. It's as if it never existed, and most investors were put back in their original position. And so some of you might be thinking, why didn't anybody sue over the DAO? And if you look at this sort of hastily grabbed picture, you'll see that at least one person tried to. That's your speaker here. This comes from the recent book that was published, The Ethereans, and it was sort of a trip to see my name and something that a letter that I wrote about 7 years ago show up in this little weird corner of history. But the DAO essentially protected itself from most litigation through the legal version of what I call security by obscurity, which is a technical term for protecting something by making it hard to find. No one was really sure who the DAO was. No one was really sure where the DAO was or who could be held accountable for the DAO. Because there was no identity required and no incorporation, there was no easy person to point to. Securities regulators, when determining that the DAO offering of tokens was the offering and sale of a security, took the position that curators, which were the people that whitelisted projects, and the code developers, those who wrote the code, could be held liable for the offering of the securities. But it's not entirely clear that every judge would have agreed. It seems more likely that a judge would have said everybody who participated is a joint venture or a general partner, which means everybody's got coextensive full liability for everything that happened, which is not a really durable and robust way to conduct business. There's a reason why we make LLCs and corporations. We want to opt out of defaults, like everyone is fully liable for everything that everybody else does. Part of the reason that folks didn't sue the DAO was, frankly, a lack of lawyers that really understood to a level of certainty what was happening, and were able to come up with real legal arguments. And the way that the attack was addressed by the Ethereum Foundation, for the most part, put most aggrieved users back where they started, notwithstanding the fact that there was a significant drop in the market price of Ethereum caused by the entire event. So although I tried, very few people got as far as actually filing a claim against the DAO, and to my knowledge, there was never litigation. Moving on to the second of the platforms that we're talking about here, we've got the Cartel Ventures DAO. This is a legal DAO, meaning that it is a DAO operated within the context of a Delaware LLC. It exists basically to do the same thing that the DAO intended to do. You buy in, the value you put in the collective venture is used for investments. But the Cartel Ventures DAO, in its LLC agreement, which it calls the Pact, was intended to include a qualified version of code deference, which means the users were expressly provided as a condition of entry the obligation to accept an LLC agreement that included contractual provisions governing whether they are required to accept what the code does as gospel or not. And they were required to agree that smart contract outcomes were presumptively correct, not to sue on claims related to smart contract outcomes, except for certain specified events, including if the waiver or limitation to bring a claim would be illegal or unenforceable, in the event of fraud or intentional misconduct, or if an event that otherwise is not illegal or is fraudulent causes one person to benefit and damages another participant. In those instances, there is an on-system ADR that allows members of the platform to hear a claim brought by a party and to decide whether the claim is valid, and if a claim is valid, to enact a corrective event on the platform. While there is a claim that is pending in this ADR procedure, the affected property and smart contract is held at a technical standstill and legally considered to be held in trust. If you don't want to use this ADR procedure and you feel you've been aggrieved, you have other options. As a passing aside, if you ever want to look at a truly original and really interestingly written contract, you should look at the Metacartel Pact. It is written in the style of Dungeons and Dragons. It is referred to as a grimoire, and it uses some really unbelievably interesting language. The ability to immediately terminate and get your assets out is referred to as rage quit. The ability to push somebody out of the venture is called guild kick. And so you can leave, you can be pushed out, or you can also, to remedy something, you can propose your own way of remedying it by creating a new proposal. The qualified code deference provisions also suggest that if someone brings a lawsuit in violation of the waivers, meaning it's not a material adverse exception event as described in the LLC agreement, that anyone who has to defend that, be it another member of the LLC or the LLC itself, is entitled to prevailing party attorney's fees. There's another venture called the LAO that we analyze, and the LAO takes a different position. The LAO says that smart contract execution in the context of its DAO is the equivalent to a written consent by the members, by the majority of the members. And that in this operating agreement, members waive the right to challenge a consented to action because it's based on it being operated through a DApp or a smart contract. And this is essentially, it creates a rebuttable presumption of correctness. To avoid this, you'd need to allege something like fraud or something like a Scrivener's error, and provide evidence to a court that says the smart contract did not behave the way that we wanted it to. Otherwise, the smart contract's execution is clothed by this presumption of correctness and by this presumption that it's ratified by the members. Apologies, I had a little noise behind me here. And this is something that's actually inherited from earlier contracts that work in a similar way. Those would be EDI master agreements. Other options are basically operating in parallel to those that we saw from the Metacartel Ventures Pact. That is, you can do a corrective proposal, you can leave, or someone can be kicked out. So when we think about this, we have two slightly different approaches to the same idea. The pact says you can't sue except for limited things, and the LAO says everything that smart contract does is correct. And if you want to try to get around it, you have to do something extraordinary by going to court. Otherwise, they get to the same place. You can propose a corrective action, you can leave the venture, or you can just file a lawsuit. So the real question then becomes, does any of this work? We're making contracts, we're coming up with these limited rights, we're implying or in certain cases requiring waivers. Does any of this work? More than likely, no. A waiver or a release or a covenant not to sue becomes a defense or a counterclaim in a litigation. You can try a contractual pre-suit injunction, but the only pre-suit injunctions that actually work, at least under US law, are pre-suit injunctions that are entered by courts that direct clerks of court not to acknowledge and receive complaints that are filed by parties usually because of abuse of the legal system, serial filers in bad faith, and so forth. And so generally that's not enforceable by private parties because we have this policy that says you can waive a lot by contract, but you can't waive things that are intended to protect third parties or where there's public policy considerations. I can't waive the driving age in Florida with my son because driving laws protect other drivers. You can't preliminarily waive the right to file a lawsuit under most circumstances without a court approving it. And so the question becomes, does this work at all? And if not, can we provide better strategies beyond those of, I guess we'll try to make it harder for people to sue? And so where we land is that while these waivers and releases and covenants not to sue make it less attractive to sue, if you try to fully foreclose the ability to sue, you run into constitutionality and due process issues. And so a full waiver may not be effective even if it is knowing, intentional, and voluntary. Ultimately, all of these attempts, whether they're by code or whether they're by law in form of private agreements, will always fail because humans, at least in the United States, with $500 and a pen, can always go file a lawsuit. And those lawsuits need to be dealt with. Assuming that they can get service on a party, you need to respond. And so the best written contract gives you defenses and counterclaims. And code may exert custodial impacts on what it is that you are doing with your smart contract code. But the legal system will still apply to the human participants. Just because we cannot make perfect code deference does not mean that it's not worth trying to get really, really close. We can use code deference provisions in law through private agreements, and we can use onboard ADR to make systems that are more attractive than litigation. By allowing folks to withdraw, by allowing folks to correct errors that happen on the system, you can create better remedies than those that are available through the legal system. Because again, if the code can be altered through internal mechanisms, you have the opportunity to have remedies that apply while the system is operating. With courts, you may be left with only ex post remedies. The point is to rebalance incentives, to make it less attractive and harder to litigate, and to provide better remedies on the system. You may be thinking to yourself, but what about anonymity? This worked for the DAO. It was hard to figure out who to sue and how to sue, and it was cross-border and nobody knew who anybody was, so maybe we should all do that. And I don't really think that that's necessarily an answer long-term for folks who want to be able to have these systems be durable and allow them to mature. I think that anonymity ultimately creates situations where an aggrieved party is going to look for anybody that they can sue because they're fairly confident that a judge will say, you're a general partner, so you have full coextensive liability for everybody else. This creates what I call the outrun the bear problem. You don't have to outrun the bear, you just have to outrun your slowest friend to get away from the bear. A system where you have anons trying to be the best anon is not really a system that's going to be scalable or ever going to be ready for prime time, in my view. The goal of code deference is to allow people to really understand what their relationships are when using these systems and to have them knowingly, voluntarily going into the system with an expectation that matches reality. Code deference would be helpful to DAOs if it was possible, because it would allow for these systems to be radically scalable and usable by persons who are operating in a number of different environments, including legal systems that may not have the same set of rights. International commerce is complicated. I'm active with the ULC and ALI on matters related to security interests in digital assets. What the Uniform Law Commission and American Law Institute do in America could be really interesting, but it's more effective if all the countries in the world adopt similar compatible laws so that secure transactions around the world could work. The dream of code deference and the dream of having users on digital asset systems participating using code only is the dream of simplifying and streamlining relationships so that resort to legal systems which may provide for discordant outcomes would simply not be necessary. We can all decide that we're going to opt into using a computer system and using a system where we have predictability about our commercial relationships without the inefficiencies of dispute resolution through extrinsic legal systems. So if there are any other questions at this point, I'd be happy to take them.
Thank you very much, Drew. And we do have just a couple of minutes if anyone would like to raise their hand. And let me also promote our next event, which is in 2 weeks' time. There will be 2 presentations by Will Song and Daryl Duffy. The title of the event is Competition or Digital Currency Competition. And I believe the chat will have the link to register. So Joseph, your hand is up. And let me quickly unmute you so that you can speak. Okay, please go ahead.
First, let me say it's an amazing presentation. I've been attending these for some time now, and the penny's beginning to drop. This is very complicated stuff. It obviously takes a lot of expertise, and understanding this innovation is really challenging to ordinary people like me. My question is a little bit outside the box. With these decentralized systems, there are tokens, and I understand how this software is amazing and will be adopted into payment systems, the fintechs. It's going to save money. It's going to make things more efficient. It's a great advancement. There's no question. How it's used, whether it's these stable coins or CBDCs or whatever it is, it's going to be interesting to see how this all evolves. But the kind of thing you're presenting today makes me appreciate at least what a challenge this is going to be, and the benefits I think will be remarkable. The thing I don't understand though is these amazing firms that provide, making all these advances are also issuing tokens. And I guess I'm stuck on an old business model here, but I don't understand why the tokens have any value. The firms certainly do. To me, the tokens are just part of the software. Is this an appropriate question for you?
I don't think they're bad questions. Why a thing has value in the abstract is probably the subject of many lengthy books. And it's probably more of a David question than a Drew question, but I'll take a hack at it. We're spoiled with fiat because we have governments that use their law to enforce value, essentially. Everyone uses the US dollar in the United States because we have legal tender laws and everybody knows you can pay your taxes with it. And so for a whole bunch of reasons, we have community buy-in that dollars are something that we're going to use to transact. We've long since had community currency laws that have allowed small communities to make their own rival currencies. And as long as they don't look like dollars, purport to be dollars, and as long as users of these currencies pay their taxes, there really isn't any issue with having community currencies. And so we've, over time, had different things as currencies. We've had specie, we've had commodity currencies, and there are many different ways that you can transact value. When people ask me, why do digital assets have value? What I say to them is 3 things. Number 1, there's a community of people that think it has value. Number 2, there are people who are willing to pay you something that you perceive as valuable for the things that you have. And number 3, we have seen the conflation of value and access to systems and products in a way that is very confounding for regulators, but which has given these assets value. If it's just someone's willing to pay you for it, then you might conclude, well, this is a Ponzi, or this is a thing that's going to go to zero. If you take that position, then literally everything in the world will also go to zero. I don't know, David, if you've got other comments on this.
Yeah, I would also give a more narrow answer that at least on some of these platforms, the tokens give you the right to be a customer or the right to vote on governance issues. And so it's actually necessary to own the tokens in order to transact. So if you find access to the platform valuable, if this is something that you want to be a customer of, that will drive up the value of the tokens, assuming that they are in limited supply. So a good example is the Filecoin token that gives you access to interplanetary file storage.
Right, and some of these tokens also pay yields to those who own them. Some of these tokens allow their users to vote on the use of aggregated proceeds.
Yeah, they look like securities in some way, shape, or form. And for the same reason, a bond is valuable, for instance. you know, that
Absolutely.
these tokens in principle could be valued. Other questions before we wrap up
Thanks
for
so much.
today?
That was very helpful.
Yeah.
Thank you so much.
Yeah, thank you for the question. Anybody else like to raise their hand? Coach John, give me just one moment to unmute you. Okay, please go ahead, Coach.
Thank you, David. Drew, I have two questions. One is, you know, how does many things in this area has not been litigated, might not have established, what do you call it, judicial precedent or case law. But how does it interact with the existing bankruptcy laws, for example? That is, let's say, you know, nobody is, in reality, let's say agent A is not able to make the payment when the time comes, even though, you can tell me whether this can happen, even though there is something under the purview of the smart contract, etc. Could one agent claim, you know, I just cannot make the payment? And does it fall under mechanisms of resolving breach of contract within bankruptcy law? This is, in other words, you know, existing bankruptcy law, does it have things to say about it? And would that be adjudicated as a bankruptcy situation?
So in the chat, I'm pasting a link to a piece that I wrote a while back that talks about smart contracts and injunctions, specifically in the context of whether smart contracts that are executory at the time an automatic stay goes into place would be perceived to violate the automatic stay if they were supplied with a condition that caused them to execute. The question of who owns an asset at a given time is a material question for what's an asset of the estate when it comes to bankruptcy. If a user becomes a bankrupt party and they have assets that are held in an executory smart contract that may or may not result in that user receiving the asset back or sending it to a third party, it may create really interesting issues about whether the automatic stay has been violated. If the smart contract doesn't execute for 91 days, is it still a preference or not? There are a multitude of really complex issues about who owns digital assets in what circumstances. Your comment was pretty general, so I don't want to go too far in the weeds, except to say this is an interesting area. There are complexities here, and there are academics that are studying this area. There are a number of law review articles out there tackling various aspects of crypto assets in bankruptcy.
Thank you.
Okay, I think it's time for us to bring down the curtain and thank our speaker. So Drew, it's always good to see you and glad that you're still at the leading edge of scholarship in the area. Thank you for joining us today. Thank you to the audience for your questions and participation. And we'll see everybody in 2 weeks at the next CBER Forum event. Have a good afternoon, everybody.
Thanks, everybody. Bye-bye.